main point. I'm going to go through, when we go through the court cases, I'm going to pretty much assume you don't know anything. That's the safest assumption for me, because these, oh yeah, I'm sorry. Thank you. Yeah. Because what happens is court cases are dealing with specific situations. These specific situations have names, and under those names are certain criteria, and that's kind of a problem for this kind of presentation, because going through all the criteria is how you actually understand the best way of what things mean, and we can't do that in the limited time we have. But I will tell you what the basic premise of the court case is, kind of what they're dealing with. Then I'll tell you the facts of the court case, and this is supposed to be kind of a what's new kind of thing, but there have been some huge impacts, and I went back to 2004, and I'll come up through 2014, but there have been some major changes. And I've also included in the slide presentation, I hope I've done it with all of them, I've put in there are 9 justices on the U.S. Supreme Court, and I've put in the decisions kind of by number. And I think you'll be amazed at how many of these court cases are 5 to 4 decisions, which means even the justices couldn't make up their minds. You got one justice changes their mind or has a different thought about something, and the law is completely reversed. What the police can do or can't do, it's completely reversed. And we'll see one of them in particular that reversed decades of practice. And again, whether you like it or not, that doesn't matter. It's what they say. So, yeah, that'd be great. I've covered this one. All right. Now, just to get you honed into where we are, we're basically talking Fourth Amendment issues here, basically search and seizure. That is the biggest portion of law, constitutional law, that deals with criminal justice, and is one of the biggest areas, period, of constitutional law. We are going to be dealing with search and seizures, and this is the bad word, reasonable. And we spend about a whole semester here trying to get students to figure out what this means, and there's no definition for it. If you think about justices that hear a case in front of them, and then they come to a 5 to 4 decision, obviously they are even having a hard time saying what is reasonable and what isn't. But the Fourth Amendment guards us against unreasonable searches and seizures. They're two different things. Easy definitions. A search is looking for something. A seizure is taking control. And there's a lot of different searches. Go ahead. Here is a list of the cases. You don't have to write these down. We're going to go through one at a time. But to give you an idea, again, I've gone back to 2004. We'll end up in 2014. And I have listed some of the situations that they're talking about here. Don't worry if you don't know what these all are. I will give you a brief little idea of what they are. But to give you an idea of how in-depth this is, in our constitutional law class, there's a chapter per every one of these. And there could be more. We could spend 2 semesters. If a police officer thinks that I am about to commit a crime, or committing a crime, or have committed a crime, they can stop me, they can detain me, and try to figure out what's going on. If you're a police officer in Cedar Rapids and you're in the business district and you turn the corner into an alley at 3:30 in the morning, and I'm walking in the alley and I see you in your marked car, and I turn around and start walking away, that's really suspicious. Police at that point can detain me for whatever time is reasonable, there's that word again, right? And try to figure out what's going on. What am I doing? You know, is it possible that I am about to commit a crime, have committed a crime, or am committing a crime? Right? So they can detain me while they bring in other cars, check the buildings, see if anything's been broken into, that kind of thing. That's basically what a stop and frisk is. All right, go ahead. All right, here's some facts of this case. This person was arrested and convicted in court in Nevada, and one of the big issues here is, if a person is stopped under these situations, under this detention, do they have to identify themselves or not? It was never been a question that the officer can ask for identification, who I am, etc. But the question is, did the person have to? All right. In this case, there was an assault, and they stopped the person to investigate and see if this was the person that committed the assault. There was a Nevada law that said if you are stopped in this situation, you must identify yourself. All right, now, so he was arrested, and he basically said that this violated two of his rights, the Fourth Amendment and the Fifth Amendment. The Fourth Amendment, because they are seizing information. Probably never thought of a seizure that way, have you? I mean, but that is. They're seizing information, my name. Fifth Amendment, if I give them my name, that may incriminate me, right, as far as committing the crime. All right, go ahead. Now, here's what the court said. The court looks at all these facts, and they usually break them down individually. So the first thing they try to decide is, was the stop constitutional? And there's no doubt it was. Okay? The police obviously had a suspicion, and when I talk about suspicion, we are talking about the lowest level of proof we have here in the United States. Very, very low. Whatever would make you the slightest bit suspicious. Then they went on to say that they have indeed in the past said some of these laws are unconstitutional. But the reason they were unconstitutional is because they were so vague. They covered way too much. But they looked at the Nevada law, and they said that's not the case. And this is what the court uses time in, like, over and over and over, is it's a balancing act. We have the privacy of the person, we have the Bill of Rights that protects the person's rights on one side, but we also have a government interest in protecting us from crime, finding out who committed crimes, prosecuting them, and so they weigh. What they said here is that this law properly balanced the intrusion on the individual rights. Yes, there was a seizure. Yes, it could incriminate him, but it balanced it with the legitimate government interest, and that's the investigation to see if this is the person in this case that committed the assault. Here's a really good example of what I was talking about. This is a 5-4 decision. Basically what this means is, if states create a law that's kind of modeled after Nevada's, then the person has to identify themselves when they're detained under a stop and frisk situation. Again, 5-4 decision. All right. So basically what this case did is not necessarily change a lot, but it upheld the practice of what the police were doing, at least in Nevada, under that law, and said to other states, if your law is similar to Nevada's, it won't be too vague, and it'll be all right. Again, 5-4 decision. All right. Now, this case, coming up in time, 2008, this case is really big because this is the one that changed decades of police practice. Arizona versus Gant had to do with an arrest. And a few things we need to talk about. When a person is arrested, they can be searched. They can be searched for evidence of a crime. They can be searched to protect the safety of the officer. And it's a pretty thorough search. You know, they can search my pockets, they can search my book bag if I have it with me, whatever. It's a pretty thorough search. The court has always held that this needs to be contemporaneous to the arrest. In other words, as soon as possible after it. It doesn't have to be right after it, but as soon as it is, you know, the officer can do it safely, you know, etc. Right? Okay. here's back to this one. Yeah, I was arrested, driving on a suspended license, handcuffed and locked in a patrol car. Then the officers went back, searched the car that he was driving, and inside a jacket pocket in the car they found cocaine. This was standard practice and was okayed by the courts. As far as going back to the vehicle, that was contemporaneous to the arrest that just occurred. There was a court case in 1981 that okayed this practice. And one of the things I want to point out to you right here is, look at the difference here. Because this court case is one that changed things. So from 1981 to 2008, and probably even before 1981 practice-wise, if I was arrested, let's say I'm driving my car, right, and I'm drunk, I get arrested for drunk driving, the police handcuff me, search me, put me in the back of a patrol car, then they can go back up to my vehicle and search the vehicle inside of it, just like they did me. And the reasoning here was, again, the safety of the officer or destruction of evidence. The constitutional question then becomes, can an officer search the vehicle as contemporaneous to this arrest when the subject is already moved, and in many cases handcuffed, and in the back of a patrol car that has, a secured area? Here's what the court held. I can sum it up in one word: no. And this changed, that 1981 to the 2008, all that law, this one court case changed all of that. And basically what the court said is, wait a minute, if the person is handcuffed and they're in the back of the patrol car, a very controlled environment, where does safety come in here? Why do you have to go back to the car as a safety issue? Because like I said, they're going to break everything down, right? So this is one of the reasons you can do this. So they don't think that applies. As far as the destruction of evidence goes, again, the person is handcuffed and controlled in the back of his car. How is that person going to destroy evidence? So, what they went on to say is that they can search only if, and there's two things, it is reasonable to believe that the arrestee might access the vehicle at the time of the search, which isn't likely, right? They're handcuffed and controlled, or that the vehicle contains evidence of the offense of the arrest. So if I'm arrested for drunk driving, if they think there's alcohol in the car, they can search it. But they need a connection. And even though this is a huge case and reverse a lot of time, right, law-wise, again, my course is very narrow. One justice changes their mind, this law could come back up, or this practice could come back up, and it could change. So this is a pretty big impact. Although, I'm not sure what impact it's actually had on policing for two reasons. One is, a lot of times there is a connection, or maybe a connection between what I'm arrested for and evidence that may be in a car. If I get arrested because I shoplifted out of a store, chances are the stuff that I shoplifted is in the car somewhere. That makes sense. Also, if I'm arrested, there's a good possibility that my vehicle will be impounded and towed, because obviously I'm not there and I'm not going to drive it. There is an inventory that goes with that, and they may find the same stuff. The third is that a lot of times there isn't any evidence to be found when you're searching a car like that. So I'm not sure of the impact, but again, it's a very narrow decision, and it did change a lot of years of law. So this is a big one as far as changing the constitutional decision and its application towards law enforcement. All right, in 2013, Florida had two major cases involving dogs. One of them, you could kind of see what the answer was going to be. It seemed fairly obvious, although there was a small twist to it. The second one was kind of a surprise. So, they've both involved dogs. They've both involved dogs sniffing the air for drugs. Okay. And, go ahead to the next one. In the first one, the guy was stopped for a routine traffic stop. The driver appeared very nervous. There was an open can of beer in the car. Sought consent, search, and the person said, no, I don't want you to search. Now, we've talked about stop and frisk. We've talked about, well, I guess the searching, right, contemporaneous kind of thing to the arrest. In a consent search, officers can always ask me for consent to search, and I can always say no. That's what happened here. They brought in a dog and did a sniff test on the car. Let's see. Anytime a dog alerts, a trained dog alerts to drugs, they can search. It gives them probable cause to search. They searched, and it turned up nothing that Aldo was trained to detect. In other words, Aldo, the dog, is trained to detect certain drugs, and the dog hit or detected, and they searched. They didn't find the drugs consistent with what the dog is trained for, but they found pseudoephedrine and other ingredients to manufacture meth. Okay? In other words, the dog was probably trained to sniff out meth, but not the stuff to make it with, and not the cold tablets that they used to make it with. Does that make sense? All right. Later, the subject was out on bail. He gets stopped again. Same dog. This time nothing's found, even though the dog hits. One of the questions before the court is, well, now, how much evidence or how much record keeping does law enforcement have to do to make the dog, and I'm going to use a term that's probably not right, but a credible witness? I'm not going to get on the stand, right? But the reliability of the dog. Now, one of the interesting things when you're talking about the reliability of a dog, and you get into cases like this where nothing's found, is we immediately jump to a conclusion. The conclusion is the dog was wrong. That's usually a bad conclusion. This is why. Dogs obviously have a very good sense of smell. When I am packaging my drugs to sell, I'm in a room that contains all this stuff, including the drug. The drug that I am packaging, I can easily see, right? Unload it up, ship it out. But what I don't see is that every place that I've had that drug, including the outside of the containers that I have the drug in, there's drugs on. I can't see it, I can't smell it, but Aldo can. The dog can. And so just because the dog alerts and the officers search and find nothing, all that means is the officer is not finding anything that they can see. Doesn't mean the drug is not there. If I package a drug in my home and I package it up, I'm not going to be able to do that without there being stuff on the outside of the package. I then put the package in my car. That minute amount, we can't even see. It's transferred to the car, the dog can smell it. Those of you that are dog people know they have extremely good noses. So that's one of the things the court was wrestling with here. The best way that I've ever heard described about dogs and their ability to smell and sniff things was by a county officer up in Northwest Iowa, and he said, think of a sandwich. When I make a sandwich and I put bread and butter and lettuce and tomato and onions and meat on my sandwich and I give it to you, you probably smell the strongest part of that sandwich, maybe the onions. But you smell it kind of as a whole, right? Dogs smell everything individually. They can tell you, well, if they could talk, right? Maybe. They can tell you what exactly is on that sandwich. They smell bread, they smell butter, they smell lettuce, they smell tomatoes, they smell onions, they smell meat. Every little thing. And so what they can do is incredible. So the court here was kind of wrestling with two things. First of all, what record keeping or whatever does a dog have to be credible in court? Because one of the things the defendant is saying, wait a minute, the dog said yes, they searched based on that, they didn't find that, they found something else. They held, because the training and testing records supported Alva's reliability in detecting drugs, and Harris failed to undermine that evidence, the officer had probable cause. So they said this is fine. But there were records there. The dog was trained. And they agreed when the argument came up that just because I can't see the drugs to seize it doesn't mean they're not there. Because again, dogs have an incredible smell, right? It did give the officer probable cause, and this is an interesting one. Everybody agreed. So there's really no question here, because the court is kind of divided these days. They really have their own little opinions. Some of them are constitutionally based, sadly some of them aren't. But for a unanimous decision, there's no question as far as what went on here. So this really didn't change a practice in law enforcement. Law enforcement uses dogs. There have been court cases on the use of dogs, many of them. They have okayed them. The only thing that they have gotten into and haven't okayed is if, like I get stopped here out on 380, kind of what time is reasonable for them to use to get a dog to me. And there's that term reasonable again. If in Cedar Rapids they have like 2 canine units out detaining me for a dog to come sniff my car, it is probably going to be reasonable because it's within Cedar Rapids. If they have to bring a dog in from another county, right, that's not going to work. That may be unreasonable. But there's still that word that we're getting at. But here, again, no question, it was a unanimous court. All right, the next one is different, and this is a little more complicated. I need to set this up by explaining to you quickly what open fields is, or more importantly, what curtilage is. Good. Sometimes folks got changes this to cartilage, and don't always catch that. It is cartilage, and the computer won't like that, but it is cartilage. Think of the area of your house and around your house is where you think is private. That's the curtilage area. Anything outside of that is open fields, and anybody can trespass into open fields. That's a weird word, isn't it? Trespass. You associate trespass with, wait a minute, you can't do that. There is an illegal form of trespass, and there is a legal form of trespass. And this is a legal form. Let me make this easy for you. What the court has, if you think of a house, and you think of the area right around the house, the yard, right, the basic yard, backyard, side, etc., that's the curtilage. But where there is access to my house, like a front porch and a sidewalk, where anybody can walk up and knock on the door, that's not curtilage, that's open fields, because the UPS person can come there, my neighbor can come there, anybody selling anything can come up on the porch and knock on the door. Now, why this is important is because that's what the court said. Not in this case, but in other cases up to this. A police officer is just like that. They can walk up to the door because everybody else can. If you live in an apartment building, think of the hallway that goes by your door. Everybody can go there, right? Unless it's a secured building, everybody can go there. Well, so can the police then. Now, in this case, go ahead. Kind of give you a loose idea of what. Here, what happened is the police took a dog, a trained dog, to the front door of this house. So instead of the officer, it's an officer and the dog. And they have the dog sniff around, and the dog detects on positive alert for narcotics. Okay. If you think about this and a vehicle, okay, they were outside the car when the dog detected for the drugs. They're outside the house here. So that, so it's emanating from within those two. They obtained a search warrant. The house, they revealed many marijuana plants, and he was charged with trafficking. The Supreme Court of Florida approved the trial court's decision to suppress the evidence. In other words, the guy is saying, wait a minute, this is against my Fourth Amendment unreasonable search and seizure. This kind of search is unreasonable. And the Florida Supreme Court and the trial court both agreed with that. The Constitution question is, was the investigation of the home under the Fourth Amendment right unconstitutional? Was it an unconstitutional search? And if the search is unconstitutional, then the seizure is also. Court's opinion, and this is where things really changed. Because again, go back to what I said. The court was going, if anybody can go there, the police can go there. And that in itself didn't necessarily change 100%, but look at the wording here. The officer's entry onto the porch was not explicitly or implicitly invited. This concept never came up in other courts. They just said, define curtilage and outside the curtilage, and here's where it is, and if anybody can go there, the police can go there. But here, they're talking something completely different. This has never come up before. So this is a big deal that they're talking about here. An officer, not armed with a warrant, may approach a home in hopes of speaking to the occupants, because that is no more than a private citizen might do. This is kind of the old idea, right? So they're still supporting what they said before. An officer can come into this area, but now they're starting to create a distinction as to when and why. The why had never been there before. And that's the interesting part about this. Now, but the court says the scope of a license is limited not only to a particular area, but also to a specific purpose. This had never come up before. So they are supporting that, yeah, an officer can go here. We've said that a lot in the past. But now we're examining the why. Why are they there? And this is obviously different than me going up in the door and knocking on the door. Here we go again. This is a 5-4 decision.